Case details are directly related to intricacies of American slavery and birthright citizenship. U.S. Constitution does not literally sanction slavery, but it does not deny it as well. They use a legal wordplay by identifying who is a, quote, free person and who is, quote, all other persons, meaning non-free or a slave person. When the U.S. Republic was established in 1777, slavery was part of the census population count for state electoral powers, embodied in the Three-Fifth Compromise, also called the Connecticut Compromise. In 1788, this requisite was formally codified into the U.S. Constitution as Article 1, Section 2, Three-Fifth Clause, that for every 3 free men will equal 5 all others, or slaves, in counting each state's population census. As a matter of law, this census constitutional requisite has been used up to the modern era. That is why U.S. Census, completed every decade, counts both voting citizens and, quote, all others, non-voting persons in a state, including legal immigrants and illegal aliens. Now, constitutional terms, once written, can never be removed, which may seem like an odd format to the legal layman, but there is over 1,000 years precedence for this legal protocol. U.S. law, in part, is inherited from prior 13 American colonies under British imperial rule. In turn, the British inherited their laws from feudal and ancient English kingdoms, one of which is the constitutional format dated back some 1,300 years. In ancient English kingdom era, noblemen clashed with the English king and compelled the king to acknowledge that any law written in a constitutional format can never be removed. This was to prevent a king from being too authoritative by removing a law at his own discretion on demand without prior approval from the nobleman. Fast forward 1,000 years to our American Republic. This de facto slavery term is still listed in our Constitution, since it can never be removed. It can only be superseded or negated by a constitutional amendment.